Welcome to Inside Medical Malpractice. This subject fascinates everyone everywhere because it affects everyone everywhere. My name is Chris Rokosh. I'm a registered nurse, legal consultant and educator, and the president of Connect Medical Legal Experts. Medical malpractice affects patients, families, nurses, doctors, midwives, healthcare institutions, the associations that define medical standards, lawyers, and the general public. Each month, we'll be looking at the malpractice issues from different perspectives, featuring honest, candid, insightful interviews by people and professionals with a wealth of information to share. Thanks for spending time with me today. Now let's dive into this fascinating subject. We're back again today with Shelagh McGregor, a plaintiff's lawyer from Weirbowen Law Firm in Edmonton, Alberta. She's also a member of the Birth Injury Lawyers Alliance and currently the president of Alberta Civil Trial Lawyers Association. If you've been listening in, you know that Shelagh has a wealth of knowledge to share with us about experts and expert reports and what makes a great expert witness. I just want to say welcome, Shelagh.
Thank you.
Thank you so much.
Happy to be here.
So I'm so glad you're here. Your input so far has been just fantastic, well-spoken and clearly said, and I know very informative to the lawyers, the public, the experts, the doctors and nurses who are out there listening. Today we're back to talk about the expert witness going to court.
That's what everybody worries about.
That's what everybody worries about. Isn't that the truth? You know, I've been doing some expert witness work since 2001, and we're filming this or recording this in 2020. I haven't been to court a lot of times. I'm sure not nearly as many times as you have, but it's surprising to me how stressful it is every time and how many unknowns there are when you're walking into that courtroom. If I could share just a little tiny bit about my own personal experience, the first time I was ever in court was when I was in court as an expert. Two things I'll tell you. I was taken completely aback by the adversarial nature of the courtroom. I'd been a labor and delivery nurse for many, many years, and the tone in the hospital setting is simply not even close to the
A little more collaborative than the courtroom?
A lot more collaborative, and there's a happy ending most of the time. I'll admit that I just simply wasn't prepared for it and was quite shocked by it. And something a little bit personal, which after my first time on the stand, I went back to my courtroom in my hotel room in a small little town in Ontario, and I discovered a little service called Dial-A-Bottle. and I'm not proud of this, but I mean, after dealing with many, many, many incredibly difficult things in healthcare, you know, many people think labor and delivery is nothing but joy and happiness, but it isn't. It's stressful and there's bad outcomes, and not every baby is wanted, and not every baby should go home with the mother who birthed it. And there's problematic social issues, you know, beyond your imagination. So I found the experience of going to court incredibly stressful. But that said, as I went more times and had some excellent support and coaching by the lawyers who had retained me, I would never say it became enjoyable. You know,
It's not meant to be enjoyable. If you enjoy it, there's something slightly wrong with you, I think.
Right. Okay,
the lawyers enjoy it. Yeah. Some lawyers enjoy it, and there is something slightly wrong with us. But
yeah, okay, you said that. I didn't, but I'll just agree with it because you're here today as the guest. But I do think that this is probably something that stops a lot of experts, or, you know, would-be experts or doctors, nurses, healthcare professionals from getting involved in medical malpractice as an expert witness. And I even know a few who it's taken out of the work of being a medical expert witness when they've gone to court once and the experience has been so negative or stressful for them that they just quit. They're like, I'm not going through that again, having my credentials, my opinions, my experience, my expertise run over, you know, like that. So in general terms, how likely is it, or how often does someone who provides expert opinion for you end up going to court and providing testimony?
It's very rare. the majority of cases do resolve before you end up going to trial.
Can you give us a number on that? Majority?
The vast majority. I would say 90% of them, if you're hired by a competent lawyer, will end up not going to trial.
And
so you have to be ready to go, but the likelihood of you actually going to court is very low.
Can you just talk about why you kind of qualified that with if you're hired by a competent lawyer? And second part of that question is, how do you know that you're dealing with a competent lawyer?
Defendants in medical malpractice cases are known to run trials with self-represented litigants, people who don't have lawyers, much more frequently because they have a much higher chance of succeeding, even if it's a meritorious case, just because the self-represented litigant doesn't really know what they're doing in court. And then,
so you're talking about someone who doesn't hire a lawyer at all.
Right.
And goes to, can that even happen?
Happens a lot.
Happens a lot. Mm-hmm. Really?
Now, most of those people don't have experts, and that's why they lose their trials. But if you're approached by a self-represented litigant, I would be very careful because that can expose you if you end up in trial. So, and then there's lawyers who dabble in it, and maybe the defendants, they recognize an opportunity to win a case that they might not otherwise win with somebody who's inexperienced. So if you have somebody who has run trials before, medical malpractice trials before, somebody with a reputation for doing this work, who it's a large part of their practice, that's what I'm referring to when I'm talking about a competent lawyer.
So if you're an expert and you get a phone call out of the blue or an email out of the blue, how would I, as an expert, kind of suss that out to determine whether or not I'm dealing with someone who's got their ducks in a row?
Right. So I would say that the internet is very helpful these days. Lawyers are all over the internet. So you can see based on their website, are they doing primarily medical malpractice? If they are, that's probably a pretty good sign that because people don't do primarily medical malpractice without being pretty good at it, because if you're not good at it, you don't make any money. So that's generally the standard that I would use if I was in an expert's shoes. Go on the internet, see if that person is doing a lot of medical malpractice, and you can get a good sense.
Good one. Okay, so back to, we're talking, our topic today is the expert at court. What can an expert expect in the way of preparation and then the court day itself, or the trial day itself, if they do end up going to court? So the whole thing's gone through mediation or settlement, has failed, I'm assuming, or has not been successful. The report's been served, and here we are. We're at trial.
Ideally, you're going to hear from the lawyer that retained you in the couple months prior to trial. Your report will have been probably a bit old at that point. So just updating with you, make sure that your opinion's the same, talk about the process a little bit, make sure that you're up to date on any new medical literature. Personally, our firm does medical literature research before a trial so we can see what's out there, and we'll provide what we have to our experts. So that way they know that there's nothing lurking.
And what might be lurking? What do you mean by that?
Especially with causation issues, like the medicine's always changing, right? Medicine's just such a rapidly advancing field that you never know what advances there've been made in the determination of whether a certain treatment is successful in preventing a bad outcome, for example. We had a case a few years ago where the cervical cerclage, that was the issue of whether there should have been a cerclage and whether it would have prevented a premature delivery, right? So that's an area where it had advanced a lot over the years. So the most up-to-date medical literature is important to know. So generally there should be some discussion in the couple months before trial. Make sure that there's nothing new, some brand new advance in medicine that affects your opinion. And just talk about the process a little bit and schedule a full briefing. So when you're going to be testifying at trial, the lawyer that's retained you should be sitting down with you and taking you through, okay, this is what we're going to be asking you. You should, by the end of the briefing, know everything that is going to be asked of you. And so you're not doing it for the first time on the witness stand. You're doing it with the lawyer, doing a full run through beforehand about what you're going to be asked and what the answers are.
And could you expand a bit on that? Like, what will you be asked? So we're talking about the examination chief by the lawyer who has retained you.
Right.
Correct? Yeah.
Generally, it's guided by your expert report. So my approach is use the expert report as my guide, go through some of your understanding about what happened in the case, what happened in the labor and delivery room or at the GP's office or whatever the circumstances are, your understanding of those facts, and then moving on to your opinion and what your opinion is. If you're providing a standard of care opinion, who you're critical of, and really explaining why. If you're providing a causation opinion, say, this is why I think it made a difference, and going through some of the medical literature, if you cited medical literature in your report, just step by step. And the lawyer will be asking you questions based on what you've outlined in your report.
In my experience, and I would imagine this is true for you working with experts and when you're doing your examination in chief, the initial examination has been all about my qualifications, my experience, my background. And in a couple of experiences I've had, I went through that and I was very sure and I was confident. But when I was cross-examined, the lawyers came up with all sorts of information on everything from information they found on a website to information in a spelling mistake in my CV, which is small, but can rattle you a little bit as an expert. And so what sort of investigation do you do? And can experts expect into their CV, their resume, their background, their work experience, maybe their Facebook page? I don't know. Where do you go to search for information that could potentially discredit, on the far side, or minimally rattle the expert that you're about to examine?
You make a good point. So before you can talk about what your opinion is, you have to establish to the court that you're qualified to give that opinion. And so that's the first part of your testimony, is talking about what your qualifications are. The lawyer who retained you will take you through your CV, and then the defense will cross-examine you on your CV, or at the other side if it's the defendant who's retained you. What lawyers are looking for in that inquiry is, do you have the experience? Were you actually working in a similar situation to the defendants at the time? Like, did you have actual knowledge in 2009, if the case is in 2009? Were you actually working then, doing that work, understanding the realities of practicing at that time? If you're a researcher, like, what do you research on and that sort of thing? A lot of what I do, if I'm looking at cross-examining a defense expert on their qualifications, is I look at what are their connections to the defendants. So that's an area that I think is really important to be careful with when you're an expert. You really do need to be impartial. And so often plaintiff lawyers will have to go outside of the province that we practice in to get somebody who doesn't know the defendant. I often encounter defense experts who are in the same city as the defendants that they've provided an opinion supporting. So what are your connections? Are you both professors at the same university? I've encountered many cases where the defense expert was actually a client of the law firm who is defending the defendant. The same lawyer defended that expert in a medical malpractice claim in prior years. So those are the sorts of things that can creep up on you if you're not careful. You really should try to be fully independent. You don't want any connections with any of the parties. That's something that you want to be careful of.
And how would the courts view that type of connection?
It's going to be interesting to see. That was an issue that I dealt with in a number of cases last year, and I don't have any decisions yet, but it depends on the judge. It depends on the connection. I think some judges will say, I think that expert could be impartial because the connection wasn't very close, whereas other judges, I think, would be aghast that that expert was willing to provide what they think is an impartial opinion, when really, how do you provide an impartial opinion when you've known the defendant? So it depends on the judge, but the last thing you want if you want to do expert work is to have a decision saying that you're not impartial.
What about social media issues? Let's say you've got a very vocal opinion against abortion or a a particular political stance or a drunkenness at a Mexican vacation, whatever the case may be. What about those types of things that are available? Can they be, number one, found and used in court against you?
Anything that is publicly available, like I do a Google search for every expert that I'm cross-examining. Well, and that I'm leading too. I want to know what's out there. So, Facebook, if your Facebook profile is public, the lawyer will likely be looking at all of that. Your publications. So if you're a researcher and you have publications in an area, we'll definitely be trying to get those articles to see if there's anything in there that's contrary to what you've put in your opinion. And there have been instances where that's been the case. Yeah, you have to be aware that, whatever you've put on for public consumption will be accessed.
That's probably scary for some people, I would think, just due to the proliferation of social media these days and the type of stuff you can find. But good advice for anybody who's thinking about being an expert. What about the CV or resume that's submitted to the court? What kind of a dig will you do in that? I once had some advice from a judge that you should prepare your CV as if the FBI were going to review it and take a look at it. What are your comments on that?
I have seen lawyers who have questioned whether the degree that you say you actually have.
Do people lie about that? Or falsify?
I think people have. I don't think it's by any means common, but I have heard of that. Lawyers are they spend a lot of time looking at, are these claims that you're making as far as your qualifications in your CV as legitimate as you make them out to be? If you say you're the director of a certain institute, are you the current director or were you interim director for 6 months? If you come across as not being fully honest with your credentials, then that can color the rest of your testimony. So it's really important that you are completely 100% honest in your CV about what your qualifications are.
And when you say it could color the rest of your testimony, what would the negative implication of that be?
Often in medical malpractice cases, it's one expert's opinion against another expert's opinion. So it's the plaintiff's expert versus the defense expert, and you're saying opposite opinions, and the judge has to decide who do they side with, who do they believe is right. And so often it's not about your opinion, it's about other things that affect your credibility. It's how you come across when you're testifying. It's how honest you are, intellectually honest you are with your CV, in other aspects of your life. For example, if you have been in contact with the defendant and you're testifying on their behalf as an expert, those sorts of things can affect the outcome even more than how much sense your opinion makes at the end of the day.
So it'd be your credibility, actually, right?
Yeah.
I mean, how believable you are as an expert.
Yep.
And certainly there's been some high-profile cases where experts either weren't believable or they falsified the information. And I would imagine that's a career ender. Is it?
Yes, I would agree with you.
Because you lawyers talk, don't you?
Oh, yeah, absolutely. Oh, yeah. And, both on the plaintiff side, we have our communication channels across Canada about different experts, and same thing with the defendants. It's a small group of lawyers that do this work, and we're very well connected.
So you're going to hear and tell if something goes on like that.
Oh, for sure. Because if something happens in our case where we realize we can't rely on an expert for whatever reason, we want to make sure that nobody else is put in the same position and has putting their client in a position where they're relying on an expert that's unreliable.
Sure, absolutely. And I think, again, this is naivety on my part, but I didn't really realize how court records are just public, so public.
Yes.
And so often now, once I'd been to court once or twice, when I was approached by a lawyer about being an expert on a case, they'd talk about the court decisions and whether or not the judge had accepted my testimony. So that sort of research in the background is stellar on your part, but was a surprise to me as an expert how your past will follow you wherever you go, because it's written in stone and it's in the public domain, and how much past court appearances influenced future court appearances.
Absolutely. I had a trial last year where one of the experts had testified as an expert in a trial on the same medical issue, on causation for the same medical issue. And there were comments in the court decision about the content of his testimony and whether he was believable, whether he was, stretching what he had to say. And then, I had that available to me when I was cross-examining. Did you testify that XYZ? The court said you did, and so, and then it also flags for you. I can see in the decision who the lawyer was, and I can call up that lawyer and say, do you have transcripts of that testimony? And then I can get the transcripts of the sworn testimony of that expert. The other thing is, too, I routinely now will do court searches for experts' names. So if it's a local expert, I'll do a court search for their name and see if they've been involved in any lawsuits, and I'll see who defended them. And often, if there is anything, it's often defense counsel on my case that they're appearing in an expert on. So, and then I have that. There's a lot of publicly available information that you need to be cognizant of.
So there's no hiding from anything that's been said or written in the past that's ended up in the courtroom.
Correct.
That's actually a really important lesson for everybody to know. I think for everybody who does this work or is considering doing this work, what types of things get experts in trouble in court? You must have some stories where you've put who you thought was the perfect expert on the stand and the situation just went south.
Yes. So one of the things that I think is very easy to get an expert in trouble is not really knowing the case, not knowing the facts of the case. And you may not realize how important that is as an expert, but you do really need to know the facts really well, because it's easy for you to get tripped up in cross-examination when the opposing lawyer is running through factual scenarios. Sometimes they'll pose hypothetical scenarios. And if you don't understand what actually happened in the case and remember what happened in the case, then that can cause problems and a lot of stress for you. So knowing that case really well is a very, very important thing. So that's one thing that can trip people up.
If you don't know the case very well, or you've forgotten, or you're just rattled under the stress of it all, are the facts in front of you or the medical record in front of you?
Yeah, so your report, which has a summary of the facts that you've relied on, will be in front of you. The lawyer who's retained you should be taking you through the important medical records that will be exhibits in the trial. And so you should have that available to you to look at. And when you're testifying, if you're thinking, there's a medical record and I just want to double check what that says as far as when a certain thing happened, you can say, I can't remember exactly when that happened. Can I take a look at that and slow it down? And you can go to the record. So there's ways of dealing with it, for sure. Because there's often people do, especially if it's their first time testifying, they get a little rattled sometimes and they need to be reminded of the facts. But there are ways that between your expert report and the exhibits.
Okay. Well, that's good to know. And I'm sure relief for people. Not everybody's good under stress, or different types of stress. I heard from an expert recently who went to court for the first time, and things like where to park and what to wear and where to sit and when to stand and when to sit. Those details stress them out. And I would imagine if we were to reverse the role and I put you in an operating room where I would be as comfortable as a, fish in water, you'd have the same kind of questions. And it's amazing. The important elements don't necessarily stress you out sometimes as much as the little details of what should I wear, those kind of things.
For sure. I would also say another thing that is really, really important is staying calm and staying even keeled, because you need to be able to hear what you're being asked. And if you're all wound up, you hear something different than what's being said sometimes when you're upset or stressed out. So trying to be calm and hearing what's actually asked of you is really important. And also sometimes defense lawyers try to get under your skin, not just defense lawyers, plaintiffs lawyers too, opposing counsel, I should say, try to get under your skin. They rattle off questions really fast. They can be a bit adversarial, and it's your job to just stay calm and come across impartial like you are. If you get wound up and confrontational during cross-examination, that's a very common way that an expert gets their testimony gets discounted. So that's another thing to keep in mind.
That's a good one to know. Staying calm under pressure. And I think most healthcare experts in their world are stellar at that. You can deal with some very, very difficult situations and stay calm. So it's just like transporting that skill from the hospital or the bedside to the courtroom. What other tricks do you got up your sleeve for rattling experts, or have you seen by opposing counsel for rattling experts?
One thing that I've seen a lot is when you're cross-examining an expert, providing a hypothetical that they haven't had a chance to consider. So often experts will provide an opinion on what they view the facts to be. But then in cross-examination, opposing counsel wants to put different potential facts to you, and then they want your opinion on that. So that is something that you can expect in cross-examination. And that can rattle you because you haven't had a chance to really think about whether that,
right,
what your opinion would be on that. And you're sort of trying to decide that on the fly. Raising your voice as a lawyer, trying to up the emotion in the room is something that I commonly see getting to experts. If there's anything that's going to get to an expert, it's that feeling of we're getting into a confrontation here. And lawyers tend to be pretty good at doing it in a fake way, but it doesn't come across as fake.
What?
We're intentionally raising the temperature in the room to, get under the skin of the witness. So keeping that in mind may help you weather that storm. Right. Knowing that it's a tactic can really help you say, I'm not biting that hook.
Right.
Yeah.
I think that helped me a lot, just realizing that there are elements of it that are a bit of theater. It's a bit of a game. But also really just being respectful and understanding that everybody's there doing a job. They're doing their job to the best of their ability. And if that entails pulling some tricks out of the bag and trying to catch you up, you just need to be able to recognize and stay calm and be there to do your job as an expert, which is to be the impartial expert witness and give testimony on your opinion.
Right. The lawyer who's retained you should be, if things are really offside, should be objecting to, certain tactics if it's over the top, and the court should be sort of regulating that too. So
right. And if that's not happening, does the expert have any recourse? If you're just feeling like, who's here for me today? Who's going to stand up for me? Can you look or make any kind of contact with your lawyer who's retained you to say, help?
Yes and no. Most of my experts are pretty, they don't do this work because they're, wallflowers. They're pretty strong. And the stronger you are in the face of that sort of thing, the better your credibility is. So you don't want to edge into confrontation and questioning, what's the relevance of that and that sort of thing. I advise my experts, if I'm not objecting to it, there's a reason why I'm not objecting to it, and so please don't object to it. So it does detract from your credibility if you start pushing back without the lawyer standing up, or often the court, if it's really offside, the court will do it.
Meaning the judge will say, will speak
the
up.
Judge will speak up even if the lawyer that's retained you isn't.
Right. There were a couple of times when I was in court where I was, like you said, asking about a hypothetical situation or whatever. I was presented with information that just really wasn't relevant. So the lawyer's standing, where he is, questioning me in the witness box and talking about an article. And I think it was really a good advice that I'd been given prior to that to ask to see the article. Like, don't just say, take the cross-examiner's word for what it is and what's written in it and how it might or might not be relevant, but to see the article. In this particular case, it was an article that had zero relevance to the case. But had I not known to say, can I see that? And having the calmness to take a moment and read it, I could have gotten in a lot of trouble just kind of responding off the cuff to something that could have otherwise been detrimental. And maybe this is a whole nother topic that we could talk about sometime in the future, is the tricks. Not that you try, but the strategies for experts in holding up in the face of the tricks. Again, being fully respectful that everybody's there to do a job. And your job, particularly as a plaintiff lawyer, understanding that if you don't win that case, nobody gets anything out of it. So it's a a serious situation that you have to try hard at, like you said earlier. Have you done every single thing you can to win that case?
And if you've done this work for a while, you'll know that it's hard to predict what will trigger the judge to decide a certain way. So some judges, you can bring forward the connection between the defendant and the expert, and they don't care. Others, it's just horrible to them. So when you're a lawyer and you're looking at that, you're thinking, okay, well, I think I have to go there because I don't know what this judge is going to do with this. And if I don't do this, and that could mean the difference for my client, then, I have to do it. I call them tactics, not tricks, because tricks suggests that maybe we're, not above board. The court should be regulating how things are coming out. But there is a lot that's fair game when you put yourself on the stand and you want the court to rely on your testimony. And that's what they're doing, right? They're relying on your opinion. And so you're going to be tested on that.
Yeah.
Yeah.
To me, that was surprising, but it's really important for anybody listening that they understand that. It's not going to be a walk in the park, and it's not meant to be easy, and it won't be easy. Let's just talk just for a minute about how you prepare experts for trial, because my experience, again, has been incredibly varied, from a quick 20-minute meeting on the courtroom steps on the day of the trial to a phone call the night before to 6 hours in a hotel room with 3 lawyers really giving you the tough cross-examination, which, by the way, at the time I thought it was terrible. But when I got on the stand the next day, I was incredibly grateful that I had been prepared in that manner. How do you prepare someone for the real-life experience of a courtroom?
I will sit down with them more than once, usually. I will have a lengthy briefing session with them sometime in the month prior to the trial, where I take them through every single thing that I'm going to go through with them. And then also what I think the defense, in my case, the opposing lawyer, will be asking them. And do a mock cross-examination and say...
And could I just ask you right there, how do you know and how much do you know about the defense cross-examination or the opposing counsel cross-examination in advance of the trial?
They don't have to tell us what they're going to do, but we can, based on our experience, we can look at, okay, what are their angles going to be? What's going to be important to them to get out of you as an expert? So their expert report gives us a lot of information about what their angle is. And so not only do I do that before trial, but then when you come to testify, come in the night before and I'll brief you the night before. And I have the benefit of knowing what the approach has been
up until that time.
So I can say, these are the areas that I think are going to be important on cross-examination, and, push you on those things, and also take you through some of the medical literature if I think that's going to be put to you, because that's something that can rattle an expert if they are presented with literature that they've never seen before.
Sure.
And your tip on that is absolutely on point. If you're going to comment on an article, you need to read that article. The court should be giving you the time to read it. If it's going to be presented to you in the middle of the trial, you should have time to read it.
Sure, absolutely.
Yeah.
Well, I think that just about wraps this up, but do you have any final words of advice or tips to give experts about their appearance in trial?
While it can feel intimidating, if you have the right support, it shouldn't be as intimidating as you might fear. Generally, being an expert is a really important role. Like, you're providing an important role in the justice system. Our system, it exists to provide checks and balances to what's going on in the world. So in the medical malpractice world, it often does change how medical practice occurs. Significant cases will change practice for the better to improve patient safety. And so you provide an important role. And if we didn't have experts who are willing to do that, then, plaintiffs' cases wouldn't be pursued, and we wouldn't be improving patient safety through this mechanism. And so while it can feel daunting, it's like a public service that you're providing.
Well said. And a good pitch for the work, because I think many experts find it hard to get involved in this. It's not an easy thing, and there can be backlash from peers and some moral and ethical issues that come into play. But certainly, I don't think it's unfair to say that excellence in healthcare is everyone's goal, everyone's goal. So I just want to say thanks to you again, Shelagh. That was another excellent session. Once again, if you want to find Shelagh, if you have a case or a potential case you'd like to discuss with her, whether you're a lawyer or a patient or a doctor or nurse, anybody potential that you'd like to speak with her, you can find her at Weir Bowen. That's WeirBowen in Edmonton. Shelagh McGregor is her name. If you're interested in expert witness work, you can check into Connect MLX or info at Connect MLX. And if you want to hear more about these podcasts and the ones we've done previous and the ones we will do in the future, go to connectmedicallegalexperts.com and click on Connect to Education. So thank you, Shelagh. It's been a pleasure.
Thanks for having me. It has also been a pleasure.